Please understand that video thumbnails are created to attract attention and may not always reflect the actual content. They are creative representations designed to engage viewers. We appreciate your understanding and hope you enjoy the video. While we strive to provide accurate and valuable information, this video is intended for reference and educational purposes only. The content reflects a collection of viewpoints and insights, selectively gathered from articles, social media posts, public forums, news sites, and online discussions. We do not claim absolute accuracy, nor is this video intended as an official or authoritative source. Viewers are encouraged to conduct their own research, compare information from multiple trusted sources, and approach all online content, including this one, with a critical and discerning mindset. This video does not intend to target or discredit any individual, organization, or nation. Its purpose is not to determine what is definitively right or wrong, but to encourage thoughtful reflection and highlight lessons we can learn from current events. Please watch with an open mind, reflect thoughtfully, and thank you for being part of this journey with us. The world stage is buzzing with significant events, and today we're zeroing in on a critical shift happening within the United States. Locked doors, border checkpoints, police vested with the authority to deport. No, this isn't a description of a distant authoritarian nation. This is the emerging reality of immigration enforcement in certain parts of America. It represents a new face, a sterner approach that's causing ripples across the country. The landscape of immigration is undergoing a profound transformation, and some states are pushing boundaries further than ever witnessed before. Why are specific states adopting measures that represent the most stringent crackdown on undocumented immigrants seen in recent history? Is this surge in enforcement truly about enhancing national security, a response to perceived threats, or is it more deeply entangled in the complex web of domestic politics, perhaps serving specific agendas? What are the real-world consequences when educational institutions begin refusing entry to children based on their immigration status, or when hospitals prioritize verifying a patient's documentation over providing immediate medical care? These aren't hypothetical scenarios. They are the challenging questions arising from policies being enacted right now. As we move deeper into 2025, the regulations governing immigration are evolving rapidly. It's not merely a tightening of existing laws. In some states, it's a fundamental rewriting of the rulebook, creating an environment fraught with uncertainty and fear for many. We are witnessing a divergence in approaches, where federal guidelines seem to be increasingly challenged by state-level initiatives. Stay with us as we explore these developments and unpack the implications. We'll delve into the specifics, examine the motivations, and consider the far-reaching effects of these policies. Remember to like this video if you find the information valuable. Subscribe to our channel for more in-depth analysis on crucial global and domestic issues, and hit the notification bell so you don't miss our updates. We also encourage you to share your thoughts in the comments below. Let us know where you're watching from and what you think about these changes. Your engagement is vital for the growth and reach of our channel. Please, make sure to watch this video until the very end, as we will be drawing conclusions from the complex information presented throughout. Let's begin our examination with Texas, often considered ground zero in the escalating immigration debate. Texas isn't just a state sharing a border. It's become a primary battleground where national policies clash with state ambitions. In the lead-up to 2025, the Lone Star State is capturing headlines for seizing control of immigration law enforcement in unprecedented ways. The passage of Senate Bill 4 marks a significant turning point. This sweeping legislation empowers local police forces not just to arrest, but potentially to deport migrants suspected of crossing into the country without authorization. The extent of this law is genuinely startling. It transforms the mere act of being present within Texas borders without proper documentation into a state-level criminal offense. Yes, you heard correctly. Simply existing in the state without papers is now classified as a crime under this new statute. This represents a dramatic escalation from previous norms, where immigration status was primarily a federal matter. But the story in Texas doesn't halt there. With an extensive border stretching over 1,200 miles with Mexico, Texas is undertaking significant infrastructure projects, notably constructing new segments of border wall funded entirely by state resources, independent of federal allocations. This raises profound questions. Are we observing the emergence of a state-operated immigration force, one that operates parallel to, and sometimes in defiance of, federal enforcement agencies like ICE and CBP? The actions taken by Texas suggest a move towards a more autonomous, state-controlled immigration system. The Lone Star State has effectively transformed its boundaries into legal fault lines, creating a complex and potentially conflicting jurisdictional landscape. Could the Texas approach serve as a blueprint, a preview of strategies that other states might adopt in the near future as they grapple with similar pressures? Or is Texas forging its own unique path, writing a distinct rulebook driven by its specific political and geographical circumstances? Regardless of the interpretation, the developments in Texas are under intense national scrutiny, serving as a focal point for the broader debate on immigration, states' rights, and federal authority. The nation watches closely, aware that the precedents set here could have far-reaching implications for immigration policy across America. Moving eastward, we examine Florida, another state dramatically reshaping its immigration landscape. In some parts of the country, lacking proof of citizenship might lead to complications, perhaps some administrative trouble. However, in Florida, under the stringent laws anticipated for 2025, the consequences could be life-altering. The state has implemented measures that tighten the screws in ways causing significant anxiety, even among residents who have lived there for extended periods. Consider the healthcare system. Hospitals are now mandated to inquire about a patient's immigration status before providing non-emergency treatment. This policy shift introduces a barrier to accessing essential medical care, potentially discouraging individuals from seeking help when needed due to fear of legal repercussions. The changes extend into the workplace as well. Employers in Florida are now legally obligated to utilize the E-Verify system, a federal database used to confirm employment eligibility. Failure to comply carries the risk of substantial fines, placing a significant burden on businesses and potentially altering hiring practices statewide. Furthermore, the validity of driver's licenses has been targeted. If an undocumented individual is caught driving in Florida, even possessing a valid license issued by another state, that license is automatically deemed invalid within Florida's borders. This measure restricts mobility and access to essential transportation for many. But perhaps the most striking element, the one sending shockwaves through communities, is the empowerment of local law enforcement. Florida police can now detain anyone they suspect of being in the country illegally, without needing intervention or authorization from federal immigration agencies. This decentralization of enforcement power means that encounters previously handled by federal agents are now potentially initiated by local police during routine interactions. The impact has been palpable. Reports indicate thousands have already left Florida, fearing that a minor traffic stop or any interaction with local police could lead to detention and deportation proceedings. It raises a critical question. Is this rigorous approach primarily about law enforcement and maintaining order? Or is it strategically designed to instill fear, encouraging voluntary departure? As these policies intensify, many Floridians and observers nationwide are questioning the long-term consequences. Is Florida setting a precedent for the future of immigration law across the United States? A future where state-level enforcement becomes the norm? The situation is dynamic, and the human and economic costs are subjects of ongoing debate and concern. Now let's turn our attention inland to Oklahoma, a state demonstrating that geographical distance from the border doesn't preclude aggressive state-level immigration enforcement. Oklahoma has no international border, no coastline, just the vast expanse of heartland highways and prairie skies. Yet, the immigration laws emerging here are raising eyebrows nationwide for their severity. In the run-up to 2025, Oklahoma stunned observers by enacting legislation that, in some aspects, goes further than measures seen even in states directly on the U.S.-Mexico border. Oklahoma has redefined the legal landscape by making it a specific state crime to reside within its borders without legal immigration status. You would be genuinely shocked by the implications. Merely existing within the state without the required federal documentation could now result in jail time under Oklahoma law. This is a significant departure, criminalizing presence itself at the state level. However, the situation becomes even more intense. Under House Bill 4156, the repercussions escalate dramatically. Anyone found without lawful presence who is arrested for any other reason can face additional criminal charges based solely on their immigration status. This means a minor infraction could trigger severe immigration-related penalties. After serving any sentence related to the initial arrest and the immigration status charge, individuals are then ordered to leave Oklahoma within 72 hours. Failure to depart or refusal to comply opens the door to further jail time. Critically, this entire process operates without the requirement for federal agency involvement. No IC, no federal warrants. It's state-led enforcement in its most direct and potent form. If you were thinking this law might be merely symbolic, a political statement without real teeth, reconsider. Local authorities across Oklahoma are actively preparing implementation plans. County jails are adjusting their protocols to accommodate these new state charges. Community groups are sounding alarms about the potential for widespread fear in fractured families, and even sheriffs have acknowledged that this fundamentally alters their approach to policing. Suddenly, a simple traffic stop, previously a minor inconvenience, could potentially initiate deportation proceedings, all orchestrated at the state level without necessarily involving Washington, D.C. This aggressive stance is not occurring in a vacuum. Legal challenges are already underway, with civil rights groups arguing vehemently that Oklahoma's law infringes upon federal authority over immigration matters. Oklahoma's counter-argument centers on protecting its residents and filling perceived gaps left by federal enforcement. Why Oklahoma? Why now? Many observers point to the rising political momentum driving such policies in Republican-led states across the nation, seeking to align local laws with broader national debates on immigration control. Consider Tennessee, a state where the dynamics of immigration enforcement are manifesting in particularly sensitive areas, like education. Imagine this scenario. One moment, a parent is preparing their child for a day at school. The next, that child is denied entry at the schoolhouse door. This isn't because of academic performance or behavioral issues, but solely because the family cannot provide documentation proving the child's legal U.S. residency. This scenario, which feels jarringly contrary to long-held principles of public education, is becoming a potential reality in Tennessee as we approach 2025. This isn't a relic from a bygone era. It's a contemporary development unfolding now. You might be stunned at how far this new legislation reaches. Lawmakers in Tennessee recently approved a bill granting public schools the authority to refuse enrollment to students who lack proof of lawful presence. In a nation where access to education has historically been viewed as a fundamental right for all children residing within its borders, regardless of their immigration status, a principle upheld by the landmark 1982 Supreme Court case Plyler v. Doe, Tennessee's actions are testing the very boundaries of that established precedent. The potential ripple effects are massive and deeply concerning. But the scope of Tennessee's new approach extends beyond school grounds. The state has also intensified its collaboration with federal immigration agencies through state-level enforcement partnerships. This often involves agreements like the 287G program, which deputizes local law enforcement officers to perform certain immigration enforcement functions. These partnerships streamline the process of identifying and detaining undocumented individuals, often leading to fast-tracked deportation procedures. Individuals detained by local police for minor offenses can find themselves quickly transferred into federal custody for removal proceedings. In counties like Davidson and Rutherford, data shows that coordination between local law enforcement and IC has reportedly doubled over the past year alone. And here's a fact that many people might not realize. Tennessee has experienced a significant and rapid increase in its immigrant population over recent years, particularly in major urban centers such as Nashville and Memphis. These immigrant communities form the backbone of various local industries. Yet instead of fostering integration and leveraging the potential of this growing population, the current legislative trend seems focused on creating barriers and fostering an atmosphere of fear. This legislation is driving fear deep into classrooms and households across the state. What happens when children stop attending school, not out of a lack of desire to learn, but because their families live in constant fear of deportation? What kind of future does this create for these children and for the broader community? Tennessee is grappling with these profound questions right now, and the outcomes will undoubtedly resonate far beyond its state lines, contributing to the national conversation about immigration, education, and human rights. Let's journey south to Georgia, a state with a history of enacting controversial immigration laws. Think back to House Bill 87, a piece of legislation that drew national attention and comparisons to Arizona's stringent SB 1070. Georgia is once again taking bold and contentious steps in 2025 to enforce immigration laws with a rigor that is unsettling communities and even causing divisions among local officials. Imagine the scene. Bustling airports like Hartsfield-Jackson Atlanta International, towering city skylines, and thriving industries powered by a diverse workforce. Yet, beneath this veneer of progress and economic activity, Georgia is tightening its grip in ways reminiscent of its past legislative battles. Under the renewed focus on enforcement, mirroring the spirit of HB 87, police officers are empowered to investigate the immigration status of individuals during routine stops or encounters if they have reasonable suspicion. This means a minor traffic violation, like a broken taillight, could potentially escalate into detention and immigration proceedings. This show-me-your-papers-style provision, while legally challenged in the past, remains a potent tool in the state's enforcement arsenal. And the enforcement doesn't stop with law enforcement interactions. Employers face harsh penalties for knowingly hiring undocumented workers, with the state ramping up audits and mandating the use of the E-Verify system for nearly all businesses employing 10 or more people. Penalties for violations are severe, including the potential loss of business licenses, which could effectively shut down operations entirely. You would be shocked at how deep these laws cut into the fabric of daily life. Local jails are required to check the immigration status of every person booked, regardless of the offense. In counties like Gwinnett and Cobb, collaboration with federal immigration agencies like ICE has surged, leading to increased detentions and deportations. This heightened enforcement has created a palpable climate of fear. For many residents, everyday errands, driving to work, going to the grocery store, visiting a doctor, now carry an undercurrent of anxiety, the constant worry that any interaction could lead to life-altering consequences like detention or deportation. It's not just law enforcement creating pressure. Access to public services is also being restricted. Proof of residency is often required for essential services, potentially limiting access to housing aid, unemployment benefits, and certain types of medical assistance for those unable to provide documentation. And here's something that might surprise you. Georgia is home to a substantial immigrant population, exceeding 1 million people, with estimates suggesting over 400,000 are undocumented. Many of these individuals have lived in the U.S., contributing to Georgia's economy for over a decade. In cities like Atlanta, they are integral to vital industries, from construction and agriculture to hospitality and healthcare. However, the current enforcement climate means many are now packing up and leaving the state, or retreating further into the shadows. Schools report declining attendance, health clinics note fewer immigrant patients seeking care, and businesses struggle with labor shortages. The economic consequences are becoming increasingly apparent. Why does this matter? Because the pervasive fear is fundamentally altering how people live. It transcends legal status. It's about daily survival. What occurs when individuals are too frightened to call the police to report a crime or abuse, or even to show up for work? Georgia is pushing the boundaries of state-level enforcement, and whether this approach becomes a sustainable model or serves as a cautionary tale of social and economic disruption remains to be seen. Consider Alabama, a state whose name became synonymous with harsh immigration laws following the passage of HB 56 years ago. What if simply being visible in public, conducting everyday activities, could place you at risk? In 2025, Alabama is demonstrating that the legacy of its stringent immigration enforcement policies is not only alive, but being reinforced with renewed vigor. Alabama's HB 56, when first introduced, was considered one of the most far-reaching state immigration laws in the nation, and its effects continue to ripple through the state. Now, parts of that law, previously challenged or dormant, are being revived and enforced with new intensity. Under these revitalized provisions, law enforcement officers are mandated to check the immigration status of individuals during any lawful stop, detention, or arrest if there is reasonable suspicion that the person is undocumented. This broad standard for suspicion has historically raised concerns about racial profiling, and those concerns persist today. But the law's reach extends far beyond police encounters. It attempts to weave immigration status checks into the very fabric of daily existence. You might find this hard to believe, but HB 56 originally included, and its spirit continues to influence, measures that make it effectively illegal to knowingly give an undocumented immigrant a ride, rent them a home, or even hire them for casual day labor. While some of the most extreme provisions faced legal challenges, the underlying intent to make life difficult for undocumented residents remains a powerful force. Everyday acts of kindness or basic commerce, things considered normal anywhere else, are potentially criminalized under the shadow of these laws. And consider the impact on education. Although federal law, Plyler v. Doe, prevents states from denying K-12 education based on immigration status, Alabama schools are still required by state law to collect data on the immigration status of every enrolling student. While students technically cannot be turned away based on this information, yet, advocacy groups argue the clear intent is to discourage undocumented families from sending their children to public schools altogether. The chilling effect is undeniable. And here's a twist you might not expect. Alabama has one of the smallest immigrant populations in the entire country. Less than 4.5% of its residents are foreign-born. So why enact and reinforce such extreme measures? Many analysts suggest it's largely symbolic, a political maneuver designed to project a tough stance on immigration and appeal to a specific voter base, rather than addressing a large-scale demographic reality within the state. It's a way to take a stand and send a potent message, regardless of the actual numbers. However, for the individuals and families living under the weight of these laws, the symbolism translates into real-world fear and hardship. Survival, not just symbolism, is the daily reality. What happens when fear becomes so ingrained that it dictates every aspect of life? When neighbors become wary of each other, fearful of inadvertently violating a complex law by offering simple assistance? Alabama is confronting these questions head-on, and the answers emerging paint a picture of communities under stress, where the social fabric is strained, and the economic contributions of many are overshadowed by the constant threat of enforcement. The long-term consequences of prioritizing such stringent enforcement over integration and community well-being are still unfolding. Flashbacks to roadside checkpoints, tense encounters with sheriff's deputies questioning passengers, and heated protests erupting outside courthouses. This isn't just a memory from Arizona's past, it's becoming the state's reality once again. Arizona, a state historically at the epicenter of America's most divisive immigration battles, finds itself revisiting its controversial playbook in 2025. The state is turning up the heat, reintroducing measures that echo the infamous SB 1070 law, which garnered international condemnation years ago. And now, in 2025, these aggressive enforcement tactics are back, and in some ways, broader than before. You would be shocked how far the new legislation and enforcement priorities go. Arizona has recently reintroduced measures empowering law enforcement officers to stop and question individuals about their immigration status during routine encounters, based on reasonable suspicion. This show me your papers provision, though legally contentious, is being applied with renewed force. Officers can detain anyone suspected of being unlawfully present, even if no other crime has been committed. Critics are sounding the alarm loudly, warning that this inevitably opens the door to racial profiling and discriminates against minority communities, regardless of their actual legal status. Supporters, however, argue it's a necessary tool to restore law and order and enforce existing immigration laws that they feel the federal government neglects. Either way, the atmosphere on the streets of cities like Phoenix and Tucson feels markedly different. In the rural areas flanking the long border with Mexico, many residents, both citizens and non-citizens, report living in a constant state of hypervigilance, uncertain about what a simple interaction with law enforcement might bring. But the enforcement push doesn't stop at individual encounters. Arizona has expanded employer audits, doubling down on e-verify requirements for businesses, and implementing new ID laws that necessitate state-issued proof of residency for accessing nearly every public service. This includes essentials like housing aid, unemployment benefits, and even certain forms of medical assistance. Imagine being denied help simply because you cannot produce a specific type of state-issued ID, even if you are legally entitled to the service. Here's something truly wild. Although Arizona's undocumented population has reportedly been shrinking for several years, the enforcement mechanisms are now harsher and more pervasive than ever. This intensified enforcement is creating significant economic consequences. Construction companies, farms, and restaurants, industries heavily reliant on immigrant labor, are reporting critical labor shortages. The state's housing industry, once booming, is experiencing delays attributed to a lack of skilled workers. But perhaps the most unsettling aspect is the human cost. Stories are pouring in not just from undocumented individuals, but also from U.S. citizens and legal residents who report being questioned, detained, or harassed based solely on their appearance or the language they speak. It's a chilling echo of the SB 1070 era, but potentially more widespread. Is Arizona simply returning to its old strategies, or is it attempting to rewrite them for a new, even stricter era of enforcement? Whichever interpretation holds true, it's undeniable that in 2025, immigration enforcement in the Grand Canyon state is no longer confined to the border itself. It permeates daily life, raising fundamental questions about who belongs, who is targeted, and what the true cost of such aggressive policies really is. Rolling farmland, tranquil towns. Iowa isn't the first state that comes to mind when thinking about the front lines of immigration crackdowns. It's a state far removed from the southern border, a place you wouldn't typically expect to be leading the charge on stringent enforcement measures. Yet, in 2025, Iowa is doing precisely that, implementing policies that are catching many, both inside and outside the state, completely off guard. You might assume immigration enforcement is primarily a concern for border states, but Iowa has proven that assumption wrong. This year, the state legislature passed Senate File 2340, a law that transforms being present in the state without lawful immigration status into a specific state crime. This legislation mirrors laws seen in states like Texas and Oklahoma, effectively criminalizing undocumented presence itself. That's correct. Under this Iowa law, individuals can potentially be arrested, jailed, and subsequently ordered to leave the state based purely on their immigration status, discovered perhaps during a routine traffic stop or other interaction with law enforcement. All of this can occur at the state level, bypassing the need for immediate federal intervention or detainers. You'd be genuinely surprised to learn how swiftly this is being enforced. Since Senate File 2340 took effect, counties across Iowa have reported a notable increase in detentions related to immigration status. This is particularly evident in areas with significant agricultural workforces, where immigrant labor is crucial. In towns like Storm Lake and Marshalltown, communities that depend heavily on these workers for meatpacking plants, factories, and farms, a pervasive sense of fear is spreading faster than ever before. But there's more to this story. Under the new law, anyone convicted of this state immigration charge faces not only potential jail time, but also automatic expulsion from Iowa upon completion of their sentence. They are typically given mere days, not weeks, to leave or risk being rearrested on new charges. And local law enforcement agencies? They are now collaborating more closely with federal agencies like ICE than previously seen in the state. This partnership expedites the process of identifying and removing individuals deemed deportable. Despite ongoing federal lawsuits arguing that Iowa's law oversteps constitutional limits and encroaches on federal jurisdiction over immigration matters. Here's something many might not realize. Iowa actually has one of the fastest growing immigrant populations in the entire Midwest. These communities are vital to the state's economy, providing essential labor for key industries. Yet instead of policies aimed at integration, the current approach focuses on enforcement and removal. Even citizens are feeling the effects. Schools are noting sudden drops in attendance as families fear deportation. Health clinics are seeing fewer visits from immigrant patients, likely hesitant to seek care due to status concerns. Religious organizations and community groups have reportedly started organizing underground support networks to provide aid to families afraid to venture out for basic necessities. Why is a state with no international border pursuing such an aggressive path? Many commentators point to national political trends and the desire among some state leaders to demonstrate a tough stance on immigration, aligning with broader conservative movements. Others suggest it's driven by unfounded fears rather than demographic realities. Regardless of the motivation, one thing is certain. Iowa is no longer a passive observer in the national immigration debate. It has actively stepped onto the front lines, implementing policies with profound consequences for its residents and its economy. Think of Louisiana. Images of vibrant gumbo cooking, the soulful sounds of jazz drifting through the French Quarter, and the serene beauty of the bayous likely come to mind. Checkpoints and detention centers certainly don't fit that picture. Yet, in 2025, the Pelican State is taking a surprisingly hard turn, enacting immigration enforcement measures that seem incongruous with its reputation for cultural richness and hospitality. This year, Louisiana lawmakers passed legislation granting local police forces full authority to detain individuals suspected of being undocumented immigrants, significantly expanding their role in immigration matters. This move allows local officers to hold individuals without necessarily waiting for instructions or intervention from federal agencies like ICE. You'd be shocked at how quickly these changes are being implemented. In parishes such as Jefferson and Caddo, sheriff's offices are reportedly already rolling out specialized immigration task units, indicating a proactive approach to state-level enforcement. Furthermore, these local agencies are utilizing the same sophisticated databases and technologies once primarily reserved for federal border agents, enhancing their capacity to identify and track individuals based on immigration status. Community leaders and civil rights advocates are raising serious concerns, warning that these policies risk turning neighbors against each other and fostering distrust between communities and law enforcement. They argue that such measures inevitably encourage profiling based on appearance or language, potentially targeting individuals regardless of their actual legal status. Even local entities are feeling the pressure. Schools and health clinics are reportedly facing new requirements or pressures to report undocumented individuals who seek public assistance or services, creating ethical dilemmas and potentially deterring vulnerable populations from accessing essential care and education. This represents a significant shift for a state known for its unique cultural blend and history of welcoming diverse populations. Fear is now following families into hospitals, schools, and even places of worship. For a state with deep cultural roots tied to hospitality and acceptance, this new chapter feels notably colder and harsher. It seems to be fundamentally changing the very soul of Louisiana, altering the relationship between the state and many of its residents. The long-term social and economic impacts of prioritizing enforcement to this degree, particularly in a state whose identity is so intertwined with its diverse communities, remain a critical question. Finally, let's turn to North Carolina. Known for its stunning beaches, thriving tech hubs in the Research Triangle Park, and deep-rooted bluegrass traditions, it's not typically the first state associated with aggressive immigration enforcement targeting local communities. However, in 2025, North Carolina is making headlines for precisely that, adopting policies that are causing significant alarm and reshaping the daily lives of many residents. The speed and scope of these changes are alarming. Just this year, the state government took decisive action by reinstating agreements, often referred to as 287G agreements, which deputize local sheriff's departments to act as immigration enforcers. This empowers local officers to investigate immigration status, book individuals based on suspected status violations, and hold them in local jails until federal ICE agents can arrive for processing and potential deportation. You would be stunned by how many counties, particularly in the Piedmont and eastern regions of the state, have eagerly signed back onto these controversial programs. And it doesn't end with empowering local police. A new state law now explicitly bans sanctuary policies statewide. This means local governments, cities and counties, are prohibited from enacting policies that limit cooperation with federal immigration detainers or refuse to comply with federal immigration enforcement requests. Those localities that defy the state ban risk losing crucial state funding altogether. Critics decry this as state-level coercion, forcing local compliance with federal immigration agendas, while state officials maintain it's about ensuring uniform application of the law and preserving public safety. But guess what? The fear generated by these policies is real and palpable. Families are reportedly pulling children out of school, afraid of potential status checks or enforcement actions near school grounds. Workers, particularly in agriculture and construction, are skipping work or relocating, creating labor shortages. Entire communities, many of whose members have resided in North Carolina for years, contributing to the local economy and culture, are retreating into the shadows, fearful of attracting attention. North Carolina has effectively changed the rules of the game. 10 states, 10 distinct approaches to cracking down on immigration, but the underlying message resonates across them all. A tougher, more localized enforcement posture is taking hold. From the southern border states like Texas and Arizona to heartland states like Iowa and Oklahoma, and southeastern states like Florida, Georgia, Alabama, Tennessee, Louisiana, and North Carolina, America is visibly altering its handling of immigration, one state law at a time. Conclusion. As we've journeyed through these 10 states, a clear pattern emerges. A significant trend towards stricter, state-level immigration enforcement is reshaping communities across America in 2025. From Texas's bold assertion of state authority with SB 4 and border wall construction, to Florida's mandates on E-Verify and hospital inquiries. From Oklahoma and Iowa, criminalizing mere presence without papers despite being far from the border, to Tennessee challenging educational rights established by Plyler v. Doe, and from Georgia, Alabama, Louisiana, and North Carolina, reviving controversial enforcement partnerships and banning sanctuary policies, the landscape is undeniably shifting. We see local law enforcement increasingly deputized as immigration agents, often bypassing traditional federal channels. Policies are impacting access to essential services like education and healthcare, creating climates of fear that affect not only undocumented immigrants, but also legal residents and citizens, particularly in minority communities. Businesses are facing new burdens and labor shortages, while the social fabric in many areas is strained by heightened suspicion and division. The central conflict remains. Are these measures genuinely driven by security concerns and a desire for law and order, or are they primarily political maneuvers, reflecting broader national debates and potentially sacrificing community well-being and economic stability for symbolic victories? The human cost is undeniable, with families fractured, children afraid to attend school, and individuals hesitant to report crimes or seek medical help. The economic consequences, from labor shortages in key industries to reduced consumer activity, are also becoming increasingly apparent. While some states justify these actions as necessary responses to perceived federal inaction or gaps in enforcement, critics argue they represent an overreach of state power, potentially violating constitutional rights and federal authority over immigration. The wave of legal challenges already underway underscores this fundamental tension. What is clear is that the United States is navigating a complex and often contradictory phase in its approach to immigration, where state actions are increasingly defining the reality on the ground, often with profound and far-reaching consequences for millions of lives. The story is still unfolding, and the ultimate impact of these crackdowns remains to be seen, but the trend towards intensified state-level enforcement is unmistakable. Thank you for joining us on this exploration.